So what happens when a plastic surgeon gets hit with defamatory reviews online? Well, in this video, I'm going to break down why plastic surgeons face unique defamation risks and exactly what you can do to fight back legally. So stick around to find out more. I'm Jake Lauder with Minc Law, the only law firm in the United States devoted exclusively to internet defamation and digital reputation issues. Our attorneys have been helping medical professionals, including plastic surgeons, fight back against online attacks for over a decade. Let me start with a shocking statistic. 51% of aesthetic plastic surgeons have experienced online reputation denigration, and 78% have faced pressure to refund fees with threats of negative reviews. So if you're a plastic surgeon, you're operating in one of the most vulnerable medical specialties when it comes to online defamation. But why is plastic surgery so different? Well, there are several specific reasons that make you a prime target. First, your patients expect perfection. Unlike other medical procedures that restore function, aesthetic surgery promises enhancement based on subjective notions of beauty. Patients come in with unrealistic expectations fueled by Instagram filters and celebrity transformations that might be impossible to achieve. When reality doesn't match their fantasy, even technically successful surgery can lead to devastating reviews. Second, these are elective procedures that patients pay for out of pocket. When someone drops 10 grand on a tummy tuck, they approach it like buying a luxury car, not receiving medical treatment. They feel entitled to perfection and aren't shy about demanding refunds or posting scathing reviews when they don't get it. Third, patients often write their reviews when they're still healing and emotional. Picture this. Someone posts a 1-star review 3 days after surgery when they're swollen, bruised, and having buyer's remorse. That review doesn't always reflect the final result, but it can destroy your reputation for years. Fourth, one review can wreck your entire brand. A single devastating review can have a disproportionate impact on your reputation. Unlike other medical specialties where patients rely on physician referrals, plastic surgery patients frequently research providers online and heavily weigh patient reviews in their decision-making process. And here's something that might surprise you. Not all negative reviews even come from patients. Research shows that 29% of plastic surgeons face defamation from other medical professionals. Professional jealousy, competition for patients, and disagreements over techniques can lead to peer-to-peer attacks that are just as damaging as patient reviews. The personal toll on surgeons is devastating. 32% of surgeons who experienced defamation reported serious mental health impacts, including anxiety, depression, and insomnia. Even worse, 22% reduced the procedures they offered, and 20% started practicing defensive medicine, seeking unnecessary second opinions just for the legal protection. So when does a negative review cross the line into defamation? Not every bad review is illegal, so understanding this difference is crucial. For something to be considered defamatory, it must meet specific legal criteria. First, it must be a false statement of fact, not just an opinion that you disagree with. Second, it must be published to a third party, which obviously happens when it's posted online. Third, it must cause harm to your reputation. And fourth, there must be some level of fault on the part of the person making the statements. Let me give you some examples. A patient saying, "I didn't like my results," is a protected opinion based on their subjective experience. But claiming, "Dr. Smith doesn't sterilize his instruments properly," or "Dr. Jones operates out of an unlicensed facility," when that's completely false, those are false statements of fact that constitute defamation. Similarly, if someone posts, "The staff was incredibly rude and unprofessional during my consultation," but they never actually visited your practice, that's also a false factual claim about your business operations. The key distinction is between a protected opinion and false statements of fact. The law protects patients' rights to express honest opinions about their care, but it doesn't protect false statements designed to destroy your reputation. Now, if you're determined that you are facing a defamatory attack, here's what you need to do. First, preserve everything immediately. Take screenshots, save web pages, document timestamps. Digital content can disappear in seconds, and you may need that evidence for any legal action later. Second, consult with an experienced internet defamation attorney right away. This is critical. We recommend that you don't try to handle this with only your general practice lawyer or malpractice attorney. Internet defamation attorneys handle this type of stuff every single day. They understand online defamation law, digital evidence preservation, platform removal procedures, and the unique challenges of internet-based attacks. Medical defamation cases that occur online require specialized expertise that general practitioners simply cannot provide effectively. When looking for the right attorney, you'll want to find someone who focuses specifically on internet defamation cases, not just general defamation law. Ask potential lawyers about their experience with online review removal, their success rate with platform takedowns, and whether they understand the technical aspects of digital evidence preservation. You should also inquire about their familiarity with HIPAA compliance issues in medical defamation cases, since this adds a complex layer that many attorneys are not equipped to handle. Don't get discouraged if a few lawyers pass on your case. Sometimes lawyers are genuinely busy and unable to take on new cases. But if you talk to several experienced internet defamation attorneys and none of them want to take your case, there might be something wrong with your legal claim, and you should reassess whether you have a viable defamation case. Third, attempt removal through the platforms with legal guidance. Most major review platforms maintain policies prohibiting defamatory content, but enforcement varies significantly and requires strategic engagement. These types of reviews generally aren't allowed on these platforms because they contain false statements of fact rather than genuine patient experiences, and these just aren't helpful for consumers. However, these platforms do not like to pick sides in disputes and are generally shielded from liability for defamation due to Section 230 of the Communications Decency Act. In our experience, it is still best to work with an attorney to report the reviews as strategically as possible, because in some cases, they will remove the issue for you without even needing to reach out to the reviewer. This is the cleanest resolution possible, so it's worth a try. Fourth, send a cease and desist letter. These are incredibly powerful tools that often resolve situations completely. A well-crafted letter explaining the defamation and demanding removal can be very effective against defamatory reviewers. The cease and desist letter will spell out for the reviewer exactly how they broke the law and the serious legal liability that they face, including potential monetary damages. But it also tells them exactly what they need to do to make the situation right, whether that's removing the content, ceasing all activity on the social media platforms, or even sometimes issuing public corrections or apologies. When defamatory reviewers realize that they could be facing a real lawsuit with real financial consequences, many of them panic and immediately comply to avoid legal trouble. This step also creates a legal record that strengthens your position if you need to file suit later. Finally, if nothing else works, file a lawsuit. Successful defamation litigation can get you monetary damages, court orders removing content, and injunctions preventing future defamatory statements. Beyond compensation, it sends a strong message that false attacks have serious consequences. What if the reviewer is anonymous? That is not a dead end. Lawyers can file John Doe lawsuits that force platforms and internet service providers to reveal the identity of anonymous reviewers. Once you know who they are, you can then pursue the full range of legal remedies. Before suing, though, consider the risks. Litigation is public and can generate unwanted attention. There's also the risk of what are known as slap counterclaims, where defendants argue that you're trying to silence their free speech. But here's the thing. Research shows that 53% of surgeons who don't respond to defamatory attacks face repeat incidents. Doing nothing often makes the situation worse. And please, don't try to handle this alone. Medical defamation cases are incredibly complex, especially with HIPAA compliance issues. Responding to reviews often requires referencing protected health information, and HIPAA violations can result in federal fines that exceed your original damages. You also risk escalating the situation or looking defensive in ways that damage your professional reputation. The bottom line is this. Defamatory attacks against plastic surgeons are serious legal matters that require professional handling. The stakes are simply too high and the laws too complex to go it alone. At Minc Law, we're the only firm in the United States devoted exclusively to internet defamation and digital reputation issues. We've represented numerous plastic surgeons over the past decade and understand both the legal landscape and the unique pressures you face. If you're facing defamatory attacks, contact Minc Law today at 216-373-7706 for a confidential consultation. We'll review your situation and explain exactly how we can help protect your good name and practice. I'm Jake Lauder with Minc Law. Thanks for watching, and I'll see you next time.